Can you imagine asking your homeowners association for a simple list of your neighbors, something you're totally entitled to by law, and then getting dragged into a legal war that lasts for years and costs thousands? It sounds pretty wild, but that is exactly what happened to one homeowner. So today, we're going to unpack how this one tiny request spiraled completely out of control.
Okay, so let's actually start at the end of the story. After nearly 4 years, countless legal filings, and way too many court appearances, the Desert Ranch Homeowners Association finally, formally admitted it broke the law. This one sentence, right here from the final decision, well, it was the finish line of a very, very long fight.
So that's really the big question we're digging into. How in the world does a simple request for a list turn into a legal saga that spans years? To figure that out, we've got to go all the way back to the beginning.
All right, let's rewind the clock. This whole massive conflict really did ignite from one single, pretty straightforward request. This is what set the entire chain of events in motion.
So here it is, the heart of the whole disagreement. A homeowner, Tom Barrs, asked for the membership roster. And we're just talking names and property addresses here, so he could, do HOA-related things. The association, they just said no, flat out. And their reason was that this basic info was somehow protected as personal, health, or financial records. That was their argument, and man, did they stick to it.
Now, what makes this so interesting is that the actual law seems incredibly clear. This Arizona statute says, right there, that an HOA has 10 business days to provide requested records. 10 business days, not 19 months. And this very law would become the central battleground for this entire case.
With the HOA digging in its heels like that, what should have been a quick 10-day task just spiraled into this exhausting and super complex legal process. I mean, how long did it actually take? Well, the timeline is pretty staggering.
Yeah, this timeline really puts the whole thing into perspective. It kicks off in October 2021. Then, fast forward to early 2023, and get this, an administrative judge actually sides with the HOA. It took another full year until April 2024 for a higher court to step in and say, nope, that's not right, and reverse the decision. That finally set the stage for the end of this whole mess in March of 2025. We're talking almost 4 years from start to finish.
And this fight came at a seriously steep price for the homeowner. Just to get the ball rolling, he had to file 4 separate petitions with the state. Each one cost a $500 filing fee. That's $2,000 right out of his own pocket before the real legal arguments even got started.
You know, the case got so convoluted that by 2025, even the judge in the final conference was confused. You can hear it right here in her own words. She's just trying to figure out how many different petitions are even on the table. It just goes to show you what a procedural mess this simple request had become. But then, the entire dynamic of the case changed. The homeowner appealed that initial decision to a higher authority, the Maricopa County Superior Court. And this was the absolute turning point.
And the Superior Court's finding was, well, it was decisive. The judge stated very clearly that a list of names and addresses does not fall under the exemption for personal records. Bam! That single ruling just completely dismantled the HOA's main defense, the one they'd been clinging to for years.
The court did add some important nuance, though. It drew a really clear line in the sand, saying that, look, while names and property addresses are essential for an HOA to even work, other info, like private email addresses and phone numbers, that stuff could rightfully be kept private. And the court's reasoning was basically just common sense, right? I mean, how can you have a community association if all the members are kept secret from one another? The court argued that for an HOA to function at all, members have to know who their neighbors are. And that simple, logical point became the legal foundation that decided the entire case.
So, armed with this definitive ruling from the Superior Court, the case got sent back down for one last administrative hearing. But this time, the outcome was pretty much a done deal. After all that time, the end came. Fast. Like really fast. At the very start of the hearing, the HOA's representative basically walked in and said, yeah, we concede. The judge called a timeout, the two sides quickly hammered out an agreement, and they came back and read the settlement. The whole years-long dispute was over in just a matter of minutes.
So, what were the final terms? Well, first, the HOA had to formally admit it violated the law. That's a big one. Second, they agreed to pay the homeowner $975, which covered one of his original $500 filing fees. And finally, for this whole multi-year ordeal, a civil penalty was assessed.
So after everything, what did this homeowner's fight for just some basic transparency actually achieve? Let's break down the final numbers because, wow, they really do tell a story all on their own.
First up, the delay. The law said the list was due in 10 business days. It took the HOA 19 months to finally hand it over. That's more than a year and a half of waiting for something that should have been almost immediate.
And the total financial compensation for all the homeowner's time, effort, and those initial costs? $975. And that includes getting his filing fee back.
And here it is, the number that might be the most stunning of all. For breaking state law for 19 months, the final civil penalty against the HOA was $25. $25.
You know, the homeowner's lawyer really summed it all up perfectly in his closing argument. He called the delay unconscionable, especially when the record showed the HOA could have done it in a single day, let alone the 10 days required by the law.
And that really just leaves us with this one big, lingering question. Sure, the homeowner won. He got the list, and the HOA admitted it was wrong. But when it costs years of your life and thousands of your own dollars just to get basic information you are legally entitled to, what is the real price of accountability?